Welcome to the module or webinar on FAPE and its interrelationship with Prader-Willi syndrome or PWS. The first slide, the title more specifically talks about FAPE, an acronym that I'll explain in a moment, for students with PWS, the legal keystone. And the meaning of keystone will also become obvious once we get into the slides. First, however, let me start with two caveats or cautions. First, it is now December 2017. I mention that because the law, being organic, changes over time, and the snapshot that we're taking right now is as of the end of the year. As a matter of fact, I checked earlier today to see if there were any new pertinent cases, and there were none. So we are current as of the end of the year 2017. Second, the perspective here is an impartial legal lens. Now, when I say legal lens, I'm referring to the fact that I'll be using as my sources not medical treatises or specialized educational practices and procedures, but rather looking at legislation, looking at regulations, and looking at cases, and using that as the source with the understanding that they will only reveal minimal legal requirements above which professional norms and these more nuanced specializations that many of you have should operate well above the level that I'm speaking about. And I also use the adjective impartial. Although I obviously have legal training to rely on these legal sources and am an attorney, I do not represent and never have represented either school districts or parents, rather gravitating to the neutral or impartial role, which is included, for example, serving for several years as a review officer in IDEA cases in the state of Pennsylvania. With those two cautions, let's move ahead and take a look at what we're talking about, including the acronyms on this cover slide. And so on our first slide, we're looking at an organizing preview of what's to come. And the first section will be to provide an overview of some of the basic building blocks of the Individuals with Disabilities Education Act, which is going to be referred to with this acronym IDEA. And we will find as we look at the act within the act that the hub or keystone is FAPE, Free Appropriate Public Education, a quoted key phrase from the IDEA, the obligation that school districts have to provide each individual child who is eligible a FAPE. And we will look within this notion of FAPE at its legal dimensions that have developed by the case law over time. And just like with human beings, we have height and weight. We start with procedures and substance as the initial legal dimensions. And we'll also examine the overlaps between FAPE and other key concepts and obligations under this act, which include LRE, or the least restrictive environment, and the remedies if a district engages in a denial of FAPE. Next, as we get even more focused, we look at a segment, a relatively small segment of the students eligible under the IDEA, those with Prader-Willi syndrome, for which we will be using the acronym that is typically accepted of PWS. And we'll be looking at the applications of the IDEA's FAPE obligation to students with PWS through cases. And when we say cases here, we're interpreting that broadly to go beyond court decisions, as you'll see when we get to the case law. And finally, we'll arrive at some overall recommendations or takeaways for you to consider in your particular pursuits, along with suggesting some references for those who want to go into more depth. With that in mind, then, let's start with the IDEA. And we find that it started as a funding act, in contrast with civil rights acts, which do not provide funding, such as Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. And when we look at the funding act of the IDEA, we find that the means of it accomplishing its purpose, which is to provide FAPE for all individual children, is through a multiplicity of procedural requirements. The one that comes to mind most immediately for FAPE is an IEP, an individualized education program, a document that records all of the aspects of a child's FAPE. And notice that the I in IDEA, like the I in IEP, emphasizes the individualized nature of this legal obligation. The act started in 1975, but it was successively amended several different times, including 1986, 1990, 1997, and most recently 2004. The 1986 amendments, for example, provided that parents, if they prevail in an adjudicative proceeding, such as a court decision, would be entitled to attorney's fees to be paid by the defendant district. This is a feature of civil rights acts at the federal level, making this original funding act more of a hybrid as time has moved on. And in its most recent amendments, which among other things emphasized outcomes, which will be somewhat significant when we talk about the substantive standard or dimension for FAPE. After each set of amendments, we have regulations. Congress passes the amendments and the president signs off. And then typically, in this case, about 2 years later, the U.S. Department of Education finalized its regulations, which incorporate all of the requirements of the legislation, but further fill in the gaps with more detailed rules. Thus, those are the basic features of the IDEA that we want to keep in mind. The second way of looking at the IDEA is to look at it in terms of the sequential obligations of school districts and rights of individual children. The first pair of obligations, which like a Venn diagram are two overlapping circles or ovals, are child find and eligibility. And that starts the district's obligation, the initial trigger being individualized like the rest of the act. When does the district, through its personnel, have reason to suspect that the child may be eligible? That is the trigger for child find. The culmination of child find is the obligation of evaluation under the act. And the purpose of the evaluation is to determine eligibility of the child. And the case law has established clearly in interpreting the definition of disability under the act that it is a two-pronged or has two essential elements. One, does the child meet the criteria for any of the recognized classifications listed in the IDEA, such as specific learning disability, or more commonly for PWS children, OHI, other health impairment? And number two, does that classification of that child have an adverse educational impact so much that the child needs special ed? Thus, boiling the two elements down more concisely, eligibility consists of classification plus the need for special education. Moving on in a checklist-like form, if the child is eligible, then the child is entitled to FAPE, here in red to point out that it is of such central significance for eligible children in general and children with PWS specifically. Overlapping with FAPE are concepts such as LRE, the least restrictive environment, which under this act is a continuum of possible placements ranging at the one extreme from a child being fully included with all of the other children in general education classes, but with supportive services, and at the other extreme, for example, an out-of-state residential placement, as we'll see in at least one of the PWS cases. And the notion is that what is the LRE for a child may well be the general ed classroom or an out-of-state residential placement or some point in between, depending upon that individual child. And finally, we mentioned earlier remedies, and the two principal remedies, although we will look at a continuum that includes other possibilities, but the two typical ones and that have the highest stakes for both districts and parents: one, tuition reimbursement, when a parent unilaterally places their child in a private placement and then seeks cost recovery from the district, or when the parent does not unilaterally place their child, but nevertheless shows that there's been a denial of FAPE, then an amount of services that the adjudicator would determine based upon various factors. And although it's retrospective, that is looking back to make up for the denial of FAPE, it is implemented or delivered in the future. And so then we move to look at the same material through a visual organizer. And when we do that, we see that this flow chart going from here left to right shows the overlap between child find and eligibility, with evaluation being the overlapping area. And then if the child is eligible, there's a meeting of the IEP team, including the parents, to develop the IEP, which would be providing FAPE, as defined subsequently in our slides, in the LRE, and in the absence of FAPE, that is a denial of FAPE, certain remedies to make up for that and to correct the situation for the future. And notice that central to the other sort of concepts here is FAPE, and that it is larger, including the fact that it accounts for most of the litigation under the IDEA. Thus, it is the hub or keystone, depending upon which analogy one uses. If we look then more carefully at FAPE, we find that it's, now remember, the act was passed in 1975. 7 years later, the Supreme Court, in a landmark decision, full title being Board of Education of Hendrick Hudson Central School District versus Rowley, the parents of Amy Rowley, a hearing impaired child. The court, the Supreme Court, in this case that some people analogize to Brown v. Board of Education, because it is so important in the history of the IDEA. The court looked at the IDEA and said, you know, it has all of these procedures, and so the first dimension that we are able to detect and will be enforced in the future is procedural compliance. Did the district fulfill the various procedural requirements for the individual child? Which, by the way, in the Rowley case, the district had done so, or at least there was no disputed issue about. But ultimately, if you do, as apparently we assume happened in Rowley, the procedures were fulfilled, What is the substantive standard? That is, what is the ultimate quality? How good does the program have to be the A in FAPE, to be appropriate? And here the Supreme Court ended up with a relatively relaxed, not a very rigorous standard. Assuming that the act is built largely on procedures, the court ended up concluding that the minimal level of FAPE is an IEP that is, and now I'm quoting from the Rowley decision, reasonably calculated to yield educational benefit. We'll come back to that final phrase of educational benefit as we move down chronologically through these steps. But so far, we've at least put in place the dimension of procedural compliance and the substantive quality of the IEP. Subsequent to 1982, all the way through to 2004, over 2 decades, we had hundreds of lower court decisions which applied the Rowley standard. And for the procedural dimension, we find that the courts ended up taking this notion of procedural compliance and ultimately coming up with a 2-step test or analysis or standard. Step 1, did the district violate procedure? And if so, a second step, did that violation result in some tangible loss to the student in terms of benefit? And if so, then it's a denial of FAPE. In 2004, Congress took that series of cases on procedural FAPE and codified, that is, actually put the rule into the act itself, and said essentially, and I'll be using this word repeatedly, for adjudications, that is, more specifically, a hearing officer or a judge may not find denial of FAPE for a procedural violation unless, and then the 2 possible or alternative conditions are either that it results in loss of benefit to the student, or reminding us that under this act, parents have their own independent rights. Did that procedural violation significantly impede the parent's opportunity for participation in the IEP process? Thus, the standard that we currently have and will see used for the procedural dimension for PWS and any other cases of eligible children would be first determining, is the proof preponderant that the district violated one or more of the procedural requirements of the act? And then if so, 2, did it result in the requisite loss to either the student or the parent? What about the substantive standard? Has that changed? Well, Congress did not readdress or codify that standard, but earlier this year, in March of this year, the Supreme Court revisited FAPE, specifically the substantive dimension of FAPE, and refined the Rowley standard, which you remember was a reasonable calculation for educational benefit, and now says, very similar, it starts off the same way, that FAPE as a substantive matter is an IEP that is reasonably calculated, but now the notion is to yield progress as a replacement of benefit that is appropriate under the circumstances, reminding us that the particular sort of environmental factors and the child may well differ. So what may be appropriate for Andrew may not be appropriate for Amy, or vice versa. So now we have three dimensions: a two-step procedural dimension, a refined substantive standard that is premised on the notion of reasonable calculation of progress appropriate under the circumstances, and developing right now in a multiplicity of lower court cases, but not yet addressed by either Congress or the Supreme Court, and without uniformity across the various federal circuit courts of appeal, that is the regional jurisdiction under the IDEA. What they all agree is that if a district did not implement an IEP, that's a denial of FAPE, but they have nuanced standards as to, well, do they have to implement it 100%? Or anything close to 100%, or only substantially, or do you take this two-step test and use that for implementation, looking at lack of implementation that resulted in loss to the student or the parent? That's not fully settled, but what is fully settled is we now have three fully settled dimensions: procedural, substantive, and what I often call as shorthand as my own little acronym, FTI, failure to implement the IEP. Those are the established dimensions that we're going to be looking at. And here we've just repeated them along with a fourth slowly emerging. We're just seeing the buds of this one. But again, let's go back just for a second to make sure it's set in our, we're all on the same page or slide. The procedural dimension has two steps, one having to do with, well, really two sub-steps, if you will. Is there a requirement in the Act for that particular procedure? And if so, did the district violate it? Then you move to, then another if so, did it result in the requisite student or parent loss? Substantive is the notion of reasonable calculation of appropriate progress under the circumstances. The FTI, or failure to implement, is either, depending upon the jurisdiction and not fully developed or uniform yet, a per se, meaning automatic 100%, or material, meaning substantial, or a two-part substantial plus benefit or progress. And finally, and we'll just see a little bit of this, but it's not a failure to implement. It's not the question of did the district implement, but we're starting to see some claims where the parent's claim is the district could not implement. It doesn't have the capability of implementing it. For PWS students, however, the cases thus far have been largely procedural or substantive, with some FTI cases and just one case that has a little bit of this ability or capability to implement the IEP. Again, making sure that the building blocks for the cases are all understood, or at least as a basic foundation. Although the two retrospective remedies I've mentioned before, in a unilateral placement case, the possibility of tuition reimbursement, or without a unilateral placement, compensatory education. Retrospective because they're making up for a past violation, although they're done in the future. Now compare that to a purely prospective order, a hearing officer or court who says, and to fix this, you need to meet very soon the IEP meeting and revise the IEP to get it up to snuff. Or, for example, an order for training of the relevant staff. At the beginning of this continuum, the most minimal form of relief is just simply a declaration that the district has provided FAPE or has not provided FAPE. And at the other extreme, not truly a remedy, but having the same financial effect. Remember back when I mentioned the 1986 amendments. If the parent shows denial of FAPE and presumably gets one or more of these remedies, thus changing the position of the district, then the parent has prevailed and is entitled to attorney's fees, which by virtue of our complicated and ponderous litigation process can in some cases be more expensive than the particular remedy. And remember, this is the parent's attorney's fees to be paid in addition to what the district has already incurred to defend itself. Thus, we now have the dimensions of FAPE, the possible remedies. Now we get to that word that I used before, and you will see its significance. That is, if we look at case law, most people think of court decisions. But under the IDEA, before you go to court, there's a general obligation to exhaust, meaning resort to, an impartial due process hearing. Sometimes people call it a DPH, by, and we'll be using this acronym, so that for those cases that we look at, which going up the hierarchy, they stopped at the hearing officer level, you will find in the citation of the case, IHO, meaning it was a hearing officer decision. Whereas if it's a court decision, in the parentheses, we'll see the citation for the court, such as D. Colorado, meaning Federal District Court of Colorado. That's the process that most people think of as case law. But the IDEA is different from many other statutes because, one, it provides this administrative hearing before going to court. But two, there is a second alternative. A parent may file a complaint with the state education department, not for a hearing, but instead for the state complaint procedures process, which we've here used the acronym CP. And there is one case so far of the PWS cases that I found for CP, but it is increasingly being used by parents because, among other things, they typically do not need an attorney, do not have to face the process of a proceeding that has witnesses, etc. Rather, once they file the complaint, the state has, within a certain specified period, an obligation to investigate and come up with a written decision for the parties, along with corrective actions or remedies if there's been a violation. And instead of this ponderous process that leads up to court decisions, but on the other hand, provides a body of case law's precedents, although it varies from state to state, in most states, the complaint procedures decision is not subject to judicial appeal. One other piece of relevance here is, notice that when I talked earlier about the two-part test for procedures and the codification in the IDA 2004, I purposely recited correctly that Congress was putting a limitation on hearing officers and courts, saying the second part of the test must be part of a denial of FAPE. However, although it again varies, a recent study that I did that is published, and I'll show you the reference if you're interested, found that the vast majority of complaint investigators, since they're not bound by that act and by these judicial precedents, take a more strict compliance view and use a one-step process. Was there a violation? And if there was, that is sufficient for them to come up with one or more corrective actions, which generically I refer to as remedies. Now, having these two avenues, we then move into the application of FAPE through the case law to students with PWS. And the first characteristic we'll see typically of these cases is that that threshold issue of eligibility is not what these cases are about, because usually if a child has PWS, he or she fits under OHI and or one of the other classifications like learning disability, and that there is an adverse effect that would require special ed. Before I leave it, let me also point out that we look at many of these cases, we find that some of these children with PWS have additional diagnoses, some of which are connected or correlated with PWS, and some are just independent conditions. Thus, eligibility is not usually the issue. Instead, FAPE is. And when we apply FAPE, we find that the characteristics of PWS frequently then, when we look at the IEP in a substantive matter, we have to look at it usually in terms of things that we might not otherwise think about for an IEP. One being food security. And that's very special to PWS, although it may be for certain other kinds of eating disorders. But here, PWS being a genetic disorder, a lifelong disorder, it becomes very, very important. Second, and this is not specific to PWS alone, but it often goes with PWS, that there are behavioral issues, and these challenging behaviors in an IEP typically require specified interventions so that the IEP does result in benefit, or in a more modern terminology, progress. Third, and this is not pervasive for all children with PWS, but again, as it is with certain other disabilities, sometimes it's not simply a matter of preparing a child for post-secondary education, but rather is the IEP resulting in progress in terms of functional academics. And finally, because PWS is a low incidence disorder, and because many folks, including me before I became aware of this whole issue, the importance of awareness to the level of training of the staff about the condition in general and about this individual child and what this individual child needs for a FAPE. Finally, although we've made some broad stereotypical characteristics here, we find that just like for any other child, students with PWS have a wide range of individual differences that must be considered when doing FAPE through an IEP that is legally defensible, much less that is at a minimum, but hopefully we will go more in terms of professionally being truly effective. With that, we have now reached the case law. And you will find that in the period from the early 80s, when most of the litigation started, all the way through till now, December of 2017, largely because it's a low incidence disability, we find a very relatively small number of cases. Of the thousands of hearing officer decisions, symbolized with IHO here, and the many hundreds of court decisions, we only have approximately 10, and by the way, remember, CP, the complaint procedures, if we look in the available databases at the national level, which are limited and only show sort of the tip of the iceberg, we find a very small percentage involving students with PWS, approximately 10 cases. But we're examining them again in terms of understanding FAPE. So what I've done for this slide is in those cases where there was one or more claims and ultimately a ruling on procedural FAPE, I then listed the cases as they fit in chronological order. And here's where I was saying I try to be impartial, but here to indicate which party prevailed in this adversarial proceeding, I had to select minus or plus. And for a change, I decided if the parent won the case, there would be a plus in front of it. But of course, these are just arbitrary and you could just flip it the other way. and a minus if it was against the parent, since in most of the cases, the parent is the moving party. Now remember that it's a two-step test. The Kern High School District case in California from 2004 illustrates this first step. The parent filed for a hearing, and one of her claims was that the kid is in high school, remember, and this child had several special education classes, only limited mainstreaming for things like music and physical education. So several of the teachers of this child were special ed teachers, and the parent took the view, understandably from a parent as well as educational perspective, that this team that is putting the IEP together should be all of these people. They should all be at the meeting. And because of this child's medical issues, the school nurse should be at the meeting. The parent, however, was using, and this is a common problem that happens, we use at times sort of our professional sense or our common sense of what we would think, but the law uses minimal requirements, although hopefully we would do better than this. But in this case, there was one special ed teacher rather than all of them, and no nurse. However, the hearing officer looked at the IDA statute, looked at the IDA regulations, and looked at the California special ed law, because each state has the ability to add to, not subtract from, the IDEA with its own laws, and found that there was no requirement in any of those laws for all of the special ed teachers or the school nurse. Thus, the hearing officer ruled against the parent. That's why there's a minus here, because there was no requirement. If there's no requirement, there's no violation. Now, let me just say as a sort of Shakespearean aside, that if you do look at this law, and if the district, for whatever reason, does not have these folks there, the parent had the legal ability to invite these folks. And if they were invited, then they become members of the team, just as long as they know about the child or special education. But that was not what this parent had done. And our focus here is to just understand, in this case, FAPE procedural. And here, step one, if it is not a requirement, or if the district has not violated a requirement, that's the end of the case. Now contrast that, and I said I did this chronologically, but contrast that California case with the next one, which was actually earlier, but here I've grouped them chronologically within the steps. The Anaheim case went to another California hearing officer, and in this case, there was a procedural violation. The written offer of placement, which is required most strongly under the California regulations, the district had not provided to this parent. Thus, they had violated the law. However, remember that if we had been in CP, that might have been a plus. But here, being a hearing officer and bound by precedent, and after 204 by the statute itself, this hearing officer went to the second step and concluded that in this case, it was in effect harmless error, because even though they did not include all the details in the written offer, the parent testified on cross-examination that she had understood and knew that the district, part of the offer was to provide all of the services from the previous IEP, and thus she knew of the missing elements, and so thus it did not harm this child, and that the parent's issue was not the amount or nature of the services, but the location. Thus, the court concluded that for these two reasons, it did not harm the child, and it did not harm the parent because they had the meaningful opportunity of participation, thus a loss. But again, we're not counting so much losses and wins as to just understanding what procedural FAPE means and how the two-step test works. Now, here's an Indiana case, which is CP. This parent filed a complaint with the Indiana State Education Department for an investigation. And the parent made various claims, of which I've listed here one as an example. And in this example, this parent said, we didn't have the opportunity for meaningful participation. The investigator interviewed the parents, interviewed the other members of the IEP team, and concluded that even though the parent may not have had the opportunity that they would regard as optimal, under the circumstances, they did have sufficient opportunity and had taken advantage of that opportunity to actively participate, even if not at an optimal level, and thus even it can be looked at one of two ways. You can either say no violation, or you can end up saying there were violations, but it did not result in a loss to the parent. Now, these are all losses. How about an example of a win? And the Green Local School District, the hearing officer decision in Ohio, is a partial win for the parent. The parent argued that the procedural violation, similar to the previous case, was that they weren't given the opportunity to participate at the level that they regarded as being appropriate. It turns out that there were 4 successive IEPs at issue in this case. And the hearing officer concluded that the parents had sufficient opportunity for the first 3, but the 4th IEP, which concerned whether this child would be entitled to a residential out-of-state placement. The placement was in Massachusetts at the Latham Center. This district is in Ohio. And when the parents first raised this issue before the hearing and sent to the district a recommendation from the Children's Institute in Pittsburgh, where the child had gone for an emergency treatment because of the severity of the child's behaviors, the Institute recommended Latham Center, and the district did not consider that recommendation. And number 2, when the parent brought more details to the meeting, it became clear not just to the parents, but to an impartial party, the adjudicator here, that they had made up their minds before the meeting and refused to budge at all or consider any possibility of residential placement, and thus they had engaged in what we can call, and shows up in the cases as, predetermination, which is a violation at both step 1, because it's procedural, and step 2 in terms of loss to the parents, as well as, in this case, the loss to the student, because residential placement was, as we'll find out, we get to the substantive rulings in this case, appropriate for this particular child. And so there have been a series of procedural cases with the result based in at least part on what the standards are, as well as are we at a complaint procedure or the hearing officer avenue. But of course, there are other factors, the individual differences among the children, who the individual is that's doing that investigation or that adjudication, and the persuasiveness of the parents, the district personnel, and the attorneys, to the extent that there were attorneys, which there typically are, at least in the adjudicative proceedings. Now, how about in substantive? Now, the first of the substantive cases, I broke the substantive cases because there are more of these rulings into 2 separate slides. One where ruling was against the parent, and then we'll revisit cases in chronological order where the ruling was for the parent. When you see a supra here, it is just simply a legal convention. Of course, we often get complicated, rely on Latin, but here we just mean above, meaning that in an earlier slide, in this case, this slide, we had the full citation. Here we're revisiting the case, and it's really just showing us that in some cases there's more than one ruling, and when there is, you can see the second or third of the rulings with this indication of supra. In Anaheim, the parent asserted that the IEP was not reasonably calculated, and this was back during the Rowley period, so reasonably calculated for benefit. The hearing officer concluded that it was not optimal, but it was reasonable, and thus the parent lost because of this relatively relaxed lower standard, which often doesn't conform to what any of us would want as a parent or a grandparent. That distinction becomes even clearer in a Pennsylvania case, which at the time had two administrative levels, a hearing officer level, and then I had mentioned that I was on a review officer panel, and there were several of these panels, and the panel that did this decision was looking at an appeal of a hearing officer decision which had been against the parent, where the hearing officer concluded that the IEP, like the previous one, was reasonably calculated. And what becomes significant for those that like analogies is that the review panel, the writer of this review panel, cited a Sixth Circuit a case that used this analogy. Parents are entitled under the Act to a serviceable Chevrolet, not a Cadillac. Now, again, we all would like a car that is better and has the features needed for the individual child. And in many cases, we should do so. But we're not talking about should, we're talking about must or shall. And at this minimal level, that's why this parent lost. But for one child, a Chevrolet might not be sufficient. And for another child, the child might indeed need a Hummer. But nevertheless, it does illustrate the difference between the perceptions of the law and the advocates, which sometimes get a bit out of sync. Now let's look at a third case. In the Broward County case, there was an IEP for a child with PWS who continued to have, among other things, food security and behavioral issues. But this district diligently reconvened the IEP team several times, not just at the end of the year, and kept fine-tuning the IEP to try to respond and more reasonably calculate the benefit of this IEP. And the hearing officer then, using the Rowley substantive standard, concluded that, once again, it may not have been the best IEP, it may not have solved all of the problems, but it met this legal standard of reasonable calculation for benefit. Now, the last two cases chronologically here, you will see in bold font. Why? Because it's a higher level of authority. Although there are more hearing officer decisions in general, more of them, because many resolve the case. For PWS, if there are approximately 10 cases, there are only 2 or 3 that are court decisions, but they have higher precedential value. And as a matter of fact, the first of the 2 is officially published, meaning that it even has more precedential value than the unofficially published case. But both of them are relatively significant. In the KC case, which is a decision from the Eastern Federal, that is the Federal District Court in the eastern side of Pennsylvania from 2011, we had a 20-year-old student with PWS. Now, first, some say 20 years old. Well, yes, the IDEA provides services from 3 to 21, or actually 0 to 21, when we look at Part C being the early intervention for infants and toddlers. But in any event, a 20-year-old is still entitled to services in that this 20-year-old had not graduated and still had needs, and he and his parents both obviously wanted to continue in the district. So the issue was not eligibility, but rather FAPE. I also point out that this child had other medical complications in addition to PWS. The parents raised two issues. One is substantive FAPE, and then we'll revisit the same case under FTI, or failure to implement the IEP. For the substantive claim, the focus was transition services, a requirement under the Act, the IDEA, that's triggered at age 16 at least, although there could be individual cases earlier. And some states it's 14, but regardless, this student is 20, thus was entitled to transition services, and the parent was dissatisfied with the transition services and said they are not appropriate, and since they're so critical to my child, my adult child, who is now 1 year away from post-secondary either education or employment, hopefully, I want effective transition services, and I don't think the services you've provided are appropriate, including a related service that is not very common, but is one of the recognized related services having to do with travel training for this student to get around independently for work and independent living. And the court ended up once again pointing out that under Rowley, because this is 2011, before we've gotten to Andrew F., under the relatively relaxed Rowley standard, the court, citing other cases having to do with transition services that have provided a rather relaxed interpretation that is far less than you will find in literature professionally recommended, but nevertheless is the prevailing case law. The court, citing this case law and the Rowley standard, concluded that the transition services were appropriate, including the provisions for travel training. And additionally, and we see this occasionally in some of these cases, additionally, because the hearing officer in this case court has what we call equitable authority, somewhat like Solomon with the classic story about splitting the baby, looking at sort of both sides, and is there contributing sort of fault on the parent side, which is not generally a very optimal way of courts looking at it. But in this case, the parents, in their efforts to try to advocate for their child, had actually looked at from an objective viewpoint, impeded the district's efforts to further individualize the transition services, or looking back at that previous case, the fine-tuning. And thus the court was essentially say, and you can't sort of blame them if you are the reason for that. But again, although I mention that as part of the rationale, it is not a very common rationale, and at least from an impartial legal perspective, the IDA is not a parent responsibility, it's a district obligation act. But when you get into this adversariality, at times, it seems that it has reached the level where the parent has contributed to the potential problem that she or he's complaining about. Then we move to a very important case, because it really sort of wraps up several of the issues involved with children with PWS. And again, it's the only other and the most recent federal district court decision, this one being from Colorado, coincidentally being the same state and jurisdiction from which the Andrew F. case first originated. But this case, unlike and before Andrew F., involved a 17-year-old with not only PWS, but multiple other diagnoses such as mood disorder and chronic anxiety, and some very severe behavioral problems. And the parents had tried various approaches on their own, as well as in collaboration with the district. And by the time that this 17-year-old had reached the high school level, and the proposal was to put him at the high school, he ended up attacking his parents and the therapist in the school parking lot, ended up in a local emergency therapeutic hospitalization, and went through a series of episodes. Sort of at one point, one of the witnesses talked about a roller coaster for both the parents and the district based on this student's behavior. And at one point also ended up at the Children's Hospital in Pittsburgh, which does emergency treatment for children with PWS. And ultimately, the recommendation in this case was for the specialized residential out-of-state placement in Massachusetts. The district, trying to resort to what we might call less restrictive alternatives, put together an IEP at the high school level that was extensive. Here are some of the provisions that it included. It had, among other things, extensive training about PWS and about this particular child for all personnel who came into contact with this student. The provisions of the IEP also included 2 specialized trained supportive aides to be with this student at all times, a very extensive set of food security provisions, a detailed behavior intervention plan, which had been fine-tuned based upon a functional behavioral assessment, reverse mainstreaming for lunch, because this child was in segregated classes and had such severe behavior. They ended up having a lunch for this child where they would invite in other children and foster social interactions for at least some interaction with other children, and a plan for increasing the mainstreaming or inclusion of the student. Also steps for, now here I'm not talking about transition services for post-secondary education. I'm talking about just simply the common sense notion that a child who has problems based upon PWS and other disorders has problems with change, and just moving him to the high school, as evidenced by that parking lot incident, shows that he has to be gradually weaned into the high school environment. And they were providing home-based instruction, counseling, other services, and slowly graduating the amount so that he would get to high school, along with transportation services with behaviorally trained personnel that extended not from the bus stop, but from this child's bedroom to the classroom. And yet the parents had become so frustrated and disillusioned and at wit's end that they wanted the residential placement. And thus we end up in court on this issue. The court ends up acknowledging and praising the parents for their extensive efforts, but pointing out that its job was not to make the law, but rather to apply the law on the Rowley applicable substantive standard of reasonably calculated. The court concluded that that IEP met the substantive standard, thus the ruling was against the parents. We'll revisit the case on their other claim, but remember, we had put on this slide all of the rulings against parents. Now we look chronologically with some repetition of cases again of substantive rulings in favor of parents. The Kern case, if you remember, we found had a ruling procedurally against the parent, but ultimately the hearing officer concluded that the IEP did not meet the Rowley standard because this student needed, at least at the year in question, functional academics, which were not in this IEP, and behavioral interventions, which were also missing. In addition, but secondarily, that there was too much segregation. It was not the least restrictive environment for this child, thus a ruling for the parent. If you go back to the array of remedies, one might have expected or hoped for a retrospective remedy of compensatory education, but because either the parents had not specifically requested the remedy, or in this case, because they had not met their burden of showing the amount of compensatory ed to which the child was entitled under the standards applicable at the time, the remedy they received was an order to fix the IEP promptly in terms of functional academics and behavioral interventions. Nevertheless, number one, the parents at least won a revision to improve the IEP for the child, and two, although not part of the decision because we're at the hearing officer level and only a court has the power to grant it if the district does not voluntarily do so, there is the foundation here for attorney's fees as well. A second ruling was in Alaska, a hearing officer, and this was it was substantive FAPE, but it was in the context of a child whose behaviors, in this case, scissors, which were, he had come at another student during an altercation with scissors. The hearing officer concluded that the scissors were not being used for their normal classroom use, and in the context of this case, constituted a weapon as defined in the IDEA, thus giving the district the right, as a matter of discretion, to place this child in an interim alternate educational setting for 45 days. They have that right, but the parent attacked the substantive appropriateness of this, if I make it an acronym, IAES. And the court, hearing officer ended up concluding that this child with PWS, like the student we saw on the previous slide, had difficulty with transitions, and the particular IAES that they had arranged in this district involved at least 3 school changes for this particular child, thus not reasonably calculated to yield benefit. And the order, again, was a prospective order to promptly change the IAES. And in the meanwhile, the hearing officer ordered about 23 hours of specified services that the district must provide to this child so that he or she could maintain benefit or progress. Another case subsequent to this one that we saw out of Ohio on the procedural side, here we're looking at the substantive side. And this hearing officer concluded that the IEP did not meet the reasonably calculated benefit standard with regard to food security behavior interventions, and the training of teachers and staff. And as a result, remember, this was the case where there were 4 IEPs in order. The hearing officer awarded tuition reimbursement at that costly out-of-state residential placement for the 4th year. But some of these cases, when we read them through the lens of the particular hearing officer and attorneys and the original complaint. It turned out, for whatever reason not shown to me in the written decision, the parent did not request unilateral placement for the first, did not request tuition reimbursement for the first 3 of the 4 years. One reason may be that they didn't give prompt notice to the district is one possibility. Another possibility may have something to do with the statute of limitations, which is generally 2 years, but could go back depending upon when the parent first knew of the violation. But in any event, the court ended up concluding, you've asked for the first 3 years as compensatory ed, but you have not shown provided sufficient information as to exactly how much or what the method of calculation should be on applicable standards. I'm not going to do it for you. In the absence of you meeting your burden, I will give you tuition reimbursement for the 4th year, as well as that prospective order to fix the IEP. At the end of this, we all end up with some lessons about substantive FAPE. But again, if we return to the human reality here, we'd find, I'm sure, some very frustrated, disappointed parents, some very frustrated staff, and folks bemoaning the costs of both the remedy as well as the attorney's fees, as well as the emotional costs of adversariality. But again, our purposes is to hopefully avoid those situations by staying at a higher collaborative level, but at the same time realizing what the standards are legally for FAPE, and in this case, substantive FAPE. There are further rulings, 2 more chronologically. In the Stoneham School District case, and I had trouble putting a plus here, and you'll see why in a minute. The parent argued that the IEP was not appropriate. The hearing officer, somewhat Solomon-like again, and given his or her equitable authority, concluded that the IEP was appropriate, but needed a modification. It was appropriate, but the district must provide in the future a one-on-one aid for the child. I considered that, on balance, a ruling for the parent because they ended up increasing the services of the IEP. But the way the hearing officer put it, at least, saying it was an appropriate IEP, one could have put a minus here. The other thing one sees, again, given the human adversariality and reactions and differences of people, the hearing officer also pointed out that, number one, the district was the one who filed for this case, and they filed because they wanted to hopefully defend their IEP, which they largely but not entirely succeeded in doing. But second, they were looking for consent for a reevaluation, which was due for this child, but the parent, who apparently was going through a stage of denial, or at least resistance, had not attended IEP meetings, had not responded to any of the paperwork, including requests for consent. Therefore, the district raised 2 issues. One was our substantive FAPE ruling, but second, a consent for reevaluation, which the hearing officer gave, and ended up at the end of the opinion in what we call dicta, meaning just some recommendations or encouragement without it having the force of an order, encouraged the parent to collaborate with this district for the sake of this student each, I'm sure, thinking they were doing what was right for this child, but the need for more collaboration, this third party tried to effectuate by recommending it. And then most recently, a hearing officer decision in Pennsylvania, where again, food security was the issue, but once again, the plus or minus is subject to interpretation. And why I say that is when one looks at the actual case, you find that the hearing officer ended up concluding that the parents' requests for revisions in the IEP were more extreme than would be reasonable. On the other hand, what the district had proposed did not meet the reasonableness standard, thus playing a sort of an intermediate or more moderated role. The hearing officer ordered various revisions to the IEP with regard to food security, but not to the extent that the parent had requested. And number two, one of the issues was not just food, but the child's exposure to food images, whether it was in instruction or in cafeteria or in extracurricular activities. And the parent, given the problems of this child's PWS, wanted complete removal of food images, arguing that that was the cause or antecedent for the child's challenging behaviors. The hearing officer ended up concluding that neither the district nor the parent had provided sufficient evidence honed in on what the relationship was between food images and behavior for the individual child. And rather than resolving it as a matter of burden of proof, more creatively came up with an order that ordered the district to collect data on the relationship between food images and the child's behavior through a qualified behavior specialist who'd been trained for this purpose for a 4-month period, and then to give this information to a specialist in functional behavioral assessments to do an FBA, then for the IEP team to meet and determine whether it is appropriate to change the IEP provisions, and if so, in what way and to what extent with regard to the parent's request for food images. Again, revealing that it's not just a matter of winning and losing, because one, some of these cases have multiple issues, and two, the adjudicator, in this case, Pennsylvania hearing officer, sometimes comes out somewhere in the middle. Now, if you remember that there is a third dimension, which is not as uniformly established, but is coming up more frequently in cases in general, as well as in PWS cases. So in the Kern case that we've already mentioned twice, one for its procedural claim, second for its substantive claim, also had a claim, which is even if the IEP is appropriate, they didn't implement it, at least not to a sufficient extent. And again, we come up with a mixed or Solomon-like ruling. The ruling was that the first IEP was sufficiently implemented, but the second of the two IEPs at issue in this case was not, and that resulted in an award and order for compensatory education to make up for the loss of the failure to implement, in addition to full implementation order for future IEPs. Similarly, we saw the Broward County case, which we saw as being a minus for the parent, a loss for the parent on substantive because the IEP included extensive training. But it turned out two of the key people that had to do with the disciplinary change in placement, one being the behavior technician who was a substitute, and the other being the principal who had decided about the interim alternating educational setting, had not attended the training, and the district had not made adequate provisions to make them make up for their absence. Thus, a violation that was material or significant for this child. But here we didn't end up with tuition reimbursement, instead a because the parent had gotten fed up, unilaterally placed the child, rather based upon the circumstances, the law, and this particular hearing officer concluded that we should fix this in the future by providing immediate and more extensive training, including for the two key folks, but not tuition reimbursement. And that was because we had a separate ruling that controlled that, having to do with substantive or procedural FAPE. The KC case, again in bold because it's a court decision, we found that there had been, with regard to physical therapy, occupational therapy, and executive coaching, a delay in implementing the IEP. However, and here we go back again to this notion sometimes of a duality of looking at the parents and by the hearing officer were identified as contributing to these delays. The court rather deftly handled it this way. It affirmed the hearing officer saying, well, the delays may be attributable to you, but we're not deciding that definitively. If we don't look at you and just look at the district and the child, we find that in any event, these delays in PT, OT, and executive coaching had not been sufficient to cause a loss to either the student, and by the way, this should be singular, to the student or the student's parents. And thus, we end up in this case applying a sort of two-step test that in some jurisdictions they use for not only procedural but FTI cases. Now, I mentioned that there was this fourth emerging dimension that is sometimes came up very briefly in that same Broward County case. And in that case, the hearing officer just mentioned it in a cursory way, and without analyzing it, just said parent didn't meet burden of proof. Zachary G., that important court decision, ended up, instead of a burden of proof, which generally is on parents or whoever files for the hearing or the appeal. In this case, the court was not looking at burden saying it's a close case, just looked at preponderance of the evidence. But in looking at, and it really was, I think, a substantive FAPE case, but it shows how these cases can be interpreted and categorized differently. I'm going to read to you from the court decision so you can hear the language. Now, remember, this is the child who had had the incident in the parking lot of the high school and where the issue ultimately had to do with an out-of-state placement. The child's name, here is public record here, is Zachary. Now, this is the judge toward the end of the opinion. It may be that if Zachary had enrolled at East High School, the district's plan would not have been effective, and that a residential placement would have been proven necessary. We cannot know because the district was denied the opportunity to show its, meaning the IEP's, efficacy. The evidence does not support plaintiff's assertion that the district was necessarily incapable of providing Zachary by implementing this IEP and its supporting implementation plans. Now, I find that language troubling, and I find it to be distracting. But the main point, if you remember the previous decision when we were there, was that the parents, and if I misspoke, I want to make sure that we've got that correct. Parents lost the case because this particular child was unilaterally placed by the parents at that out-of-state placement, and thus we had no solid evidence. We only had speculation as to whether, as a matter of definitiveness, the IEP would have worked. In trying to explain that at the end, which is the language that I was reading to you from Zachary, the court ended up by talking about denied the opportunity as, again, in effect, pointing the finger at something that parents have a right to do, that is a unilateral placement, taking the risk that they may or may not get tuition reimbursement, and talking about this notion of capability, which surfaced then here. But basically what I'm saying is this fourth dimension has not fully flowered at all, and in the two cases just evidences itself in a small, very insignificant way. What is more significant for the rest of us are the takeaways. And hopefully what you're taking away from this webinar is, now we can look at it from the point of view, as I will here, because we did so with our plus and minus for parents of children or students with PWS, but we'll find these same lessons apply not only to parents more generally, but also to district personnel and other interested personnel like private specialists, related service personnel, and neutrals like hearing officers. And that is one takeaway, is that for procedural FAPE, in addition to remembering that two-part test, that a parent and thus a district has to be aware of the alternative for complaint procedures, where often it's not a two-part test, it's a one-part test, and thus increasing the rigor and obligation for districts and the chances for more favorable rulings for the parents. With regard to the second dimension, substantive FAPE, whether you're the parent, or in my case, the grandparent, or district personnel, I laud you for working at an optimal level, at a best practice level. But with regard to the law, push comes to shove, and we go to the administrative investigative or the adjudicative alternative. Moderate your legal expectations, because this notion, even under Andrew F., is reasonable calculation for progress. And if you read Andrew F. from an impartial legal lens rather than an advocate's or politician's legal lens, you find that it doesn't have as much rigor as some who say it's a game changer that it would have generally. On the other hand, Andrew F. does emphasize something that we've seen throughout, starting with Rowley, that what is substantively appropriate or reasonably calculated for progress will vary greatly depending upon the individual child and the individual circumstances. Third, implementation. Again, first, moderate your expectation legally, because in most jurisdictions, here's this notion of jurisdictional standard, thus far in most jurisdictions, the requirement is not 100% or even like 95% implementation, which one might expect ethically, but it's usually less. However, consider again the complaint procedures alternative, where a per se or strict standard tends to predominate much more clearly, because they're not bound by those same standards that the courts are develop and are bound by. Overall, in conclusion, My view is, hopefully I've helped you become legally literate. And it does pay to have an objective notion as to what the sort of baseline, what the legal requirement. But it is to the benefit of the child and the system and our culture to avoid this legal complexity and costly, ponderous, time-consuming process. Instead, going back to focus, whether you're the parent or the district or any other interested individual, to focus on effective collaboration, trust, partnership, and professional norms. Now, there's going to be lack of consensus. There's going to be some honest division of opinion here. But if we can stay at that level and work it out, even through compromise, negotiation, and if need be, alternative dispute resolution, such as facilitated IEPs, we're saving the district, the government, the taxpayer, and the rest of us, not only the undue fiscal costs, but the adversariality that goes along with spiraling litigation. But again, my job and my knowledge and skill is all at this legal level. I thank you all very much for your patience with me, with my presentation, and even with my moving along here with this PowerPoint. I very much hope that it is useful for you.